My topic this afternoon is the unconstitutionality of judicial supremacy. And you'll be hearing a lot about this subject today, as I understand it. So I think I'd better define some terms to begin with. By judicial supremacy, I mean the theory that the Supreme Court has the authority to construe the Constitution in the course of deciding the cases and the controversies that come before it. Also, that an opinion of the Supreme Court on an issue of constitutional construction determines the meaning of the Constitution on that point of law, not simply as against the particular parties who happen to be involved in that case, but in principle as against everyone else in the world, and in particular as against Congress, the President, the states, and even we, the people. That is, the opinion, once the Supreme Court has enunciated it, becomes and is the supreme law of the land, which everyone else is required to follow. Judicial supremacy also includes the concept that a point of constitutional law that is set out in an opinion of the Supreme Court that decides an issue of constitutional construction can be overruled or modified in only two ways. First, by another opinion of the Supreme Court, it can change its mind later on, or by a formal amendment of the Constitution under Article 5. And finally, judicial supremacy teaches that nothing can be done to the justices of the Supreme Court as a consequence of any opinion that they hand down on an issue of constitutional law, no matter how obviously wrong it may be. Now let me contrast judicial supremacy with judicial review. Judicial review simply says that the Supreme Court has the authority to construe the Constitution in cases or controversies that come before it, and that an opinion on a constitutional issue is binding on the actual parties to that case. Jones versus Fenster, it's binding on Jones and Fenster, but on no one else. Now, thirdly, you can contrast both judicial review and judicial supremacy with what's called stare decisis, which simply means an earlier opinion of the Supreme Court will be followed by a later court unless they find something wrong with it. And the purpose of that is really to maintain a certain amount of stability in the law so you don't expect opinions to be changing every other day, although that apparently seems to be what's happening in any event. Now, one of the interesting points about judicial supremacy is that it has been more or less a disaster. You can go back to Calder versus Bull, where they destroyed the ex post facto clause. You can go to Barron versus Baltimore, where they refused to apply the Bill of Rights to the states. You can go to Scott versus Sanford, where they declared that people of African origin could not be citizens of the United States. You can go to the famous money cases post-Civil War, Knox, Juilliard. You can go to the infamous Gold Clause cases of the Roosevelt era. And in fact, you can go through almost any Commerce Clause decision of the Supreme Court, including my favorite, which was actually a money case, McCulloch versus Maryland, way back when under John Marshall. And you will find that in every one of these instances, the result was essentially disastrous. Now, that ought to lead one to the conclusion that there's something wrong with this doctrine, because the Founding Fathers were not such imbeciles as to lay a rather large brick of disaster in the middle of the foundation that they were building. However, it's even more important to notice that the very fact that we can discuss these cases as being right or wrong or disastrous, which is my favorite word because that's the one that usually applies, means that we are intellectually rejecting judicial supremacy right here and now. We are denying that the court's decisions are the Constitution. Otherwise, we would have to conclude that the cases are right and that the Constitution's at fault. All right. Now, what's the present consequence of judicial supremacy? It establishes a non-representative and irresponsible oligarchy, which is intent, as the court's recent decision in Lawrence versus Texas proves, on restructuring America according to an alien ideology that it is at war with the principles of Western civilization. And in fact, Justice Kennedy, who wrote the majority opinion in that case, specifically says that the principles on which he is deciding go in an opposite direction from the moral and ethical principles of Judeo-Christian civilization. In an opposite direction. What direction is that? Is that Satanism? I mean, what's the opposite direction? All right? Now, my wife would never allow me to write that kind of idiocy in anything that I produce. But apparently no one vets opinions of the Supreme Court to kind of cross that out and say, editorially, we can't accept this. All right. So what we have here is an elitist subversion of the Constitution, but even more so an elitist subversion of popular self-government. A diversion of power from we the people and we the people's elected representatives to the judges, and even more than the judges' law clerks, and even behind the judges' law clerks, the professors in the law schools, because they are the ones that really determine the whole flow of intellectual sewage that ends up in court opinions. And not only that, but this is really an opiate of the people, if I may draw from Marx, right? We do not have control of our own constitutional destiny because someone else is controlling it. They're so smart, they're so expert, they know so much more than we do. We can't understand any of this stuff, that's why we need them, right? Well, then how are the people to govern themselves under these circumstances? How can the people administer their government by electing officials unless they understand what it requires and whether the officials are living up to it? That is the Constitution. Are they simply to take the Supreme Court's word for this when we know that the court has been wrong in the past and has admitted it time and again? How many times have they reversed their own constitutional decisions? Dozens of times. This is, as they say in the law, an admission sotto voce, in a low voice, right? We do it, but we don't tell you how important it is to notice it, right? Is it possible that the Founding Fathers had this in mind when they wrote the Constitution? Right. Now, let's look at a couple of simple fallacies. I love to deal with fallacies because they're so prevalent in the judicial area. Judicial supremacy itself is circular. It's what logicians call petitio principii, begging the question, all right? What is their argument? We, the judges, have the power to declare with finality what the Constitution means for the time being, and our decisions can be reversed only by a constitutional amendment unless we reverse them, once again by declaring with finality what the Constitution means for the time being. And I ask, well, how do we know that? And they answer, because we, the judges, have interpreted the Constitution as giving us that power. And I ask them, how do we know that you're right? Because the Constitution gives us the final power to interpret it. Therefore, whatever we say is right. You follow that logic? And I'll tell you something right now, there is no more to it than that. There is no more to it than that. Now, the other argument that's always thrown up is, well, we have the rule of law. And if we didn't have judicial supremacy, we wouldn't have the rule of law. Well, of course, that depends upon what the rule of law means, doesn't it? What rule of law? Determined by whom? How? When? According to what criteria? Judicial supremacy is not synonymous or always consistent with or necessary for law at all. It's just as easy to say that judicial supremacy is the epitome of the rule of men. It depends what the Constitution has provided to determine what the rule of law is. Now, if you go back historically, and you cannot interpret the Constitution without putting yourself in the historical frame of reference of the founders and the we the people that ratified it, you will discover that there is no precedent in pre-constitutional Anglo-American law for judicial supremacy. Not a single one. In fact, Blackstone, in his commentary, says that allowing the judiciary to overrule the legislature would be subversive of all government. That's an exact quote. Subversive of all government. That was the background which the Founding Fathers approached this whole problem. When they came to the Constitutional Convention, this concept was rejected twice. First, there were people who proposed a council of revision in which members of the Supreme Court would participate, voted down. Then they actually asked to give Supreme Court justices a negative on acts of Congress, voted down. So this is not a matter of something that slipped under the door that they hadn't thought about. Furthermore, the concept of judicial supremacy contradicts the only rational way to interpret the Constitution, which is original intent. Now, what is original intent? Original intent does not mean what Madison thought necessarily, or what Jefferson thought necessarily, or Gouverneur Morris, or anyone else, because they could have been wrong on any particular issue. And in many instances, they were. And they fought among themselves on many issues, especially Hamilton and Jefferson. How do you know which one of those Founding Fathers was right? Right? You have to put yourself in the frame of a reasonably intelligent American versed in the law of that time, understanding the language that was used and the historical antecedents of the Constitution, and read what it says objectively on its face, what in contract law is called the objective theory. What would this mean objectively to someone else? Not what do I personally think about this, or what did Madison personally think about it. Well, all right. That being the doctrine, and it had to be the doctrine. Why? Because they had nothing else to go on at that time. Madison's notes, when were they published? Years after the Constitution was ratified. And William Crosskey, the famous scholar now deceased from the University of Chicago, believes that a large amount of those notes was falsified for political reasons. All right? So no one relied upon Madison's notes. The so-called state constitutional conventions, where were they reported? In the newspapers. You go look at those, Eliot's debates, and you'll wonder how anyone could even think to use those as a basis for interpreting the Constitution, especially given that half of the people that spoke in those constitutional conventions were trying to defeat the Constitution, not to ratify it. Right? There was no Supreme Court initially. When that Constitution was ratified, there was no Congress, there was no president, there was no Supreme Court. If judicial supremacy was the rule, how did the people who ratified the Constitution know what it meant? Did they ratify something they didn't understand? Rather difficult. Article 2, Section 1, Clause 7, the oath of the President. Well, we heard about that in an earlier seminar. Article 6, the oaths of all state officials, congressmen, judges. How could those people, the first ones who came into office, have rationally or morally taken an oath to a Constitution they didn't understand, that would only be interpreted years later, and in many particulars has not been interpreted yet by the Supreme Court? Impossible! It's a physical as well as a moral impossibility. I could stop here. You want me to go on? I mean, I can go on forever. It's insanity. All right? It also, judicial supremacy, also contradicts the basic principle of popular sovereignty. So I asked this gentleman here in the front row, see if anyone else can answer this question quickly. What are the three most important words in the Constitution? We the people. Hey, you don't need me. You know the answer. We the people. Everything else flows from those three words. What are the most important words to judicial supremacy? We the judges. Contradiction. All right? Basic contradiction. Judicial supremacy is also obviously destructive of the Constitution's basic structural elements. And what are they? Delegation of limited powers. Right? Division of powers or separation of powers. Checks and balances. Every one of those is stripped away by judicial supremacy. It's not a delegation of limited powers when the court can say anything it wants and force the people to amend the Constitution to override that decision. It's certainly not a division of powers when the court can tell the President and Congress, as well as the states, who have some powers reserved to them, what they can or cannot do. And where are the checks and balances in the system when nothing happens to the Supreme Court when it enunciates some piece of trash like the Lawrence case? Well, let's go to the constitutional text. Maybe I'm wrong. Maybe I'm just not reading this closely enough. All right? Maybe it's hidden in there somewhere. Written in Sanskrit. There are footnotes of some kind. I can't get to it. Article 3, Section 1. You know, always when there's a problem with the machinery, read the book of instructions. Especially if the thing is as dangerous as a chainsaw, which this clearly is. Article 3, Section 1, judicial power. Did the concept of judicial power mean judicial supremacy under the standing Anglo-American law in the late 1700s? What did Blackstone say? It would be subversive of all government to put the judiciary above the legislature. So clearly it did not. And Blackstone was more or less the secular Bible of lawyers. Blackstone's commentaries had sold more copies than any other legal text at that time. Now, the Constitution also goes on in that provision to say that judicial powers shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. Well, you can't necessarily derive judicial supremacy from that. You can probably derive judicial review from it because those cases will come before the court to decide, but it doesn't follow because of that decision that the Congress, the President, and the states are bound by it. All right? So you can't derive that directly from the extension of that power. What about the judicial oath? That's a fascinating one because that goes back to Marbury versus Madison. Remember, Marshall says in Marbury versus Madison, we judges take an oath to support the Constitution, this oath would be hollow if we did not put the Constitution ahead of any mere statute that we believed violated the Constitution. Right? We'd be committing, in essence, perjury. Right? That leads you perhaps to judicial review, although as Marshall says in Marbury versus Madison, it would also lead you to congressional review, they take an oath, to presidential review, he takes an oath, to state government and state judiciary review, they take oaths. Right? It certainly doesn't lead you to judicial supremacy unless the Constitution has judicial supremacy written somewhere else that when you take the oath, you must accept. See, it's another one of these interesting circles. Well, what about the Supremacy Clause? You know, that's a fascinating one. State judges generally take two oaths. They take one to the state, and they take one to the United States. So the Supremacy Clause of the Constitution says that anything in the constitutional laws of any state to the contrary notwithstanding, the state judges must abide by the Constitution. And apparently the Founding Fathers thought that was necessary to subordinate the state oath to the United States oath. Right? Apparently they believed that without that extra Supremacy Clause mandate, the state judges would not be supreme with respect to federal law. In fact, they could follow their own state law. That's a fascinating little tidbit that kind of slips in sideways whenever anyone discusses this subject. The final language, and this was actually used in the Marbury case, this was some language that Marshall was fairly pleased with in terms of his argument. The in pursuance language in the Supremacy Clause, right? Laws made in pursuance of the Constitution shall be the supreme law of the land. And he says, well, that means that if substantively they're in violation of the Constitution, they can be set aside. The only difficulty with that is that that language at that time had a number of meanings. One is the simple procedural sense. We're doing this under or following the Constitution. That is, Congress is passing a statute in the normal course of legislative events, they're taking a vote, and so forth and so on. It does not lead to the conclusion that one can substantively review the result of Congress. It certainly doesn't give either judicial review or judicial supremacy, because if the Constitution doesn't allow any one of those things, then a law that is passed in pursuance of the Constitution has an applied immunity from them. It's another circle, right? You have to leap out of all of this nonsense, kind of step away and say, wait a minute, you know, there's kind of grade school logic that we're dealing with here. Now, if it means in conformity with, let's give them the benefit of the doubt. Let's say in pursuance means it has to be in conformity with the Constitution. A law has to be in conformity with the Constitution to be constitutional, otherwise it can be set aside. What about a Supreme Court decision? First place, a Supreme Court decision does not rise to the level of a law. You can find that in Blackstone. You can actually find that in early Supreme Court decisions all the way up to Swift versus Tyson in 1842, I guess it was. It's evidence of what the law is, but it is not itself the law. Why? Because it can be wrong. The Constitution is neither right nor wrong, leaving aside the ultimate moral question. It simply is. But a Supreme Court decision, an opinion about the Constitution, can be right or wrong, usually wrong. Right? And therefore, it clearly does not rise to the level of a law. All right, well, from that it follows that if a law should be set aside because it is not in pursuance of the Constitution, then clearly a Supreme Court decision ought to be set aside if it is not in pursuance of the Constitution. And then the question is, who decides that in a system of checks and balances? It cannot be the persons who are making the error. There's no check and balance if they're the same ones that decide whether it should be set aside, right? That's not a check and a balance. And if you think this thing through, that whole argument leads us to the conclusion that every petty judge, all the way down to whatever, the lowest level judge in any court in any state or city, township or whatever, has the authority of some kind of judicial supremacy until he, she, or it is overruled at some stage later on. And once again, I can't imagine that the Founding Fathers would have extended that kind of license down to essentially any petty judge. Well, Marbury versus Madison really is, as most constitutional professors, I guess, will tell you, is the key decision. Everything is kind of spun out of that. But all Marbury versus Madison said was that the Supreme Court could exercise judicial review. Congress had passed a statute that purported to give the Supreme Court the power to issue certain common law writs within its original jurisdiction. And if one reads the Constitution, at least on the face of it, without getting into the complexities of the matter, it doesn't seem that that was consistent with the limited jurisdiction and original jurisdiction the Constitution gave the Supreme Court. So what Marshall was saying was, Congress cannot interfere with our judicial prerogatives by putting on us more duties or giving us more powers than the Constitution did, and we are defending our own judicial bailiwick, as it were. And to defend our own judicial bailiwick is judicial review. It is not judicial supremacy. It simply says, we're not going to do this. You can keep passing those laws, but when they come to us to exercise, we're not going to do them. How one could derive from that the conclusion that that decision would be binding on anybody else in the world, even Marshall didn't explain, because he knew he wasn't saying that. Right? It has been spun out later on. Well, now let's come back to the checks and balances point, because I think that's one of the most important pieces of evidence here. One would think that if the Founding Fathers had given the Supreme Court judicial supremacy, and given the fact that a lot of what goes on in constitutional law has political ramifications and it's controversial and there are going to be all sorts of difficulties and fights, that the Founding Fathers would also have given the Supreme Court the ability to protect itself against the other two coordinate branches, which might, on certain occasions, not be willing to accept the decision of the Supreme Court. President Jackson, for instance. John Marshall has made a decision, now let him enforce it. All right? We have that example. Right? Now, looking at the Constitution, one can see immediately that the judicial supremacy is totally implausible because the Supreme Court has essentially no effective means to protect itself from counterattacks by Congress and the President. Congress and the President can pack the court. We don't like this decision, we'll put another 18 people on. And we'll have 27 justices, we'll get a decision the next day. They'll reverse everything these people did. Right? Impeachment or conviction. Actually, I think they can go further than that. I think they can remove them under the good behavior language of the Constitution, which is obviously less than impeachment. Imagine a situation where a justice becomes mentally deranged. Is that a high crime or misdemeanor to become mentally deranged? No. But it can't be good behavior to be deciding cases when you're mentally deranged. Right? So there must be a way to remove these people short of high crimes and misdemeanors. Now, it just so happens that making decisions against the Constitution is perjury, because they took an oath not to do that, right? So that's clearly a high crime and misdemeanor. But why go to high crimes and misdemeanors? 18 U.S. Code 241, 242. Criminal violation of civil rights. Read that sometime. It sounds as if it was written for this Supreme Court. All right? They can be indicted. No problem. 18 U.S. Code sections 241 and 242. People should memorize it. Have one of those little things, you know, those little cards, right? Plasticine cards are written right down there, because it applies to every public official. All right. Not that often enforced, but it's there. And there is another provision, of course, dealing with the jurisdiction of the courts. Congress has the power to limit the appellate jurisdiction of the Supreme Court and to completely control the jurisdiction of the federal district courts and the federal circuit courts, and to create absolutely new federal district courts and federal circuit courts. It could take all the jurisdiction away from the ones that exist now and put it all in another group over here, and those justices, all they would get is their salaries. They could sit down there. I would give them, you know, copyright cases arising out of comic books, and that would be what they'd hear. And then we'd have a completely new set over there. So Congress could change the composition of the court system overnight. Through Section 5 of the 14th Amendment, Congress shall have the power to enforce the rights in Section 1. It could go after the state court judges. Oh, there's no limit here. Think about that. Put those two together sometime. So you'll see that there are really no checks and balances working from the side of the Supreme Court to Congress, and certainly not the inferior federal courts. None whatsoever. So judicial supremacy exists essentially by the sufferance of Congress and the sufferance of the President. Well, I won't go into why they're suffering this. I think the main reason ultimately is they like to push off controversial issues to the Supreme Court and then come back later and say, oh, our hands are tied, we can't do anything about this, so difficult, you know, we'd like to do something, but we can't, the Supreme Court rule. Right. I want to get on to something else which comes down to the practical matter, having spent years in the courts, too many years in the court system. Remember, the Founding Fathers, to a large extent, were lawyers. practicing lawyers, in fact. Most of them at least some background in the courts. Yeah, Hamilton, for instance, a good example. You don't usually think of him as one, but he was. So they would have known the practicality of what we understand as the litigational system. It hasn't changed much. Think about this situation. Here's the Supreme Court. Here's the Constitution. How often do these come into congruity? Very infrequently. There are huge areas of the Constitution that have never been touched on by the Supreme Court. How do we know that a decision will lead to the right constitutional question even being asked? By the right people, depends on the party, depends on the lawyers, depends on the facts that happen to be in the case, all adventitious, all fortuitous. Maybe it'll depend on the right time. The circumstances won't be propitious for this kind of a case. And even if the right questions are asked, how do we know the right answers are going to be given? The answers that will not only interpret the Constitution correctly, but will interpret it in a way that leads to long-term stability. Remember, because they're always paraphrasing in an opinion, and they're always dealing with the circumstances of the case that comes before them. And one of the grave problems that we have is, of course, that the justices do not, in fact, decide the vast majority of the cases that come before them. Who does? The clerks. The clerks. The clerks decide the vast majority of cases that are going to be heard because they are winnowing out the cases that they don't think are important. And then, of course, they're doing research and they're providing arguments. And where do those arguments come from? Well, they come from the latest hula hoop theory out of some law school. Right? Who are these people, these clerks? They just came out of law school. They spent 3 years in law school learning what? God knows what. They probably never spent a day in a courtroom. Right? Maybe they spent another year clerking for some lower federal court judge. And then they're going up and advising the Supreme Court on how to review and decide constitutional questions. It's an absurdity on its face. Anyone with any brains would say, oh, the people we want to bring in clerks are retired lawyers. They should be at least, what, 55, 60 years old. They should have gone through the whole system to see how corrupted it really is. That's very important, especially in the criminal law. Oh, my goodness. They should be people that are totally cynical and hardened and totally removed from careerism. Their careers are over. They're not going to make their career by stepping out of their clerkship and going to Fenster, Shylock, and Mouthpiece and making large bucks. And so you see the system that we have is exactly the opposite of what any intelligent person would set up. Right. Now also the court comes to us over and over again saying, well, we're not going to decide whole categories of questions. Right? They have to be justiciable, which we determine. The party has to have standing, which we determine. We won't give advisory opinions, and that's a matter of our advice. Right? We're going to advise you on that. We won't answer political questions, the ones that are too difficult or scary for us to answer, right? And we won't decide constitutional questions unless they're absolutely unavoidable. And you know, if we say they're avoidable, right? Which means we don't have to do anything we don't want to do. Don't show me no stinking badges. All right? Okay? And I give you one classic example, the Gold Clause cases. This is my favorite. I don't know if you remember the Gold Clause cases from the 1930s that Congress had abrogated provisions in public and private contracts, bonds, public bonds, private contracts, that required payment in gold coin. Threw them all out. And the key argument on which the Supreme Court upheld Congress's act in those three instances was that Congress had taken the gold from the American people, brought it all into Fort Knox, called in all the gold, and that therefore none of the litigants in these cases could have gotten gold anyway, and so they weren't entitled to any relief other than getting the nominal value of their bond or contract in paper money. And you would say, okay. Except for one thing, you would say, okay. Did the Supreme Court ever decide a case in which it was held that Congress could call in all the gold of the American people? I see smiles there. No, you don't have to be a legal scholar to know. You know the answer right away, right? They never decided that. Now, what's fascinating about that case is that issue was presented to them, and they decided it, to take it, not to take that issue, but to take the Gold Clause cases on the very same day in their conference. All right? That issue was there, and they knew that they were going to decide these three other cases on the basis of that issue They didn't take the case that raised the issue, and then in the 3 gold clause cases, they simply assumed that the government could take the gold. All right? One of the most obviously deceitful cases that ever came down. And you know how you find that out? The way I found it out. You go back and you look at 320 volumes of the Supreme Court briefs from 1933, 34, and 35. Brief by brief, because they have no index. Until you find the cases that were raised. Actually, there were 3 of them by the same litigant. He lost $200,000 in gold bullion. So he was a little hot about it. 3 cases he brought to the Supreme Court simultaneously.
He's hot now.
Excuse me?
I think he's hot when he brings them. You should wait until he hears that they're not going to hear it.
Yeah, right. I can imagine. Well, he was criminally prosecuted, so he was even hotter. I mean, he had all sorts of problems.
That'll teach him.
That'll teach him. That'll teach him. And he was a lawyer. That should have taught him right there. All right? Okay. 3 cases. And it's fascinating because in that particular case, remember there was a dissent. It was a 5-4 decision. The 3 gold clauses, a 5-4 decision. And even the dissenters said nothing about it. Even the dissenters kept quiet. I mean, the fix was in from the word go. I often thought the reason was that they were very scared. If they had come out the other way, you know, there would have been tremendous political consequences. But that simply goes to show you that judicial supremacy as a protector of the Constitution is meaningless. Because if that wasn't an example of where judicial supremacy should have been used, I can't think of one. All right? Now, I just contrast here Justice Stephen Field. Someone mentioned Justice Stephen Field. I have a quote from Justice Stephen Field. Pollock versus Farmers Loan and Trust Company. And we've had all these doctrines that the Supreme Court has invented as to why they shouldn't hear a case. And here's what Justice Field said in the Pollock case. The law of Congress being of a public nature affecting the interests of the whole community and attacked for its unconstitutionality in certain particulars may be considered with reference to other unconstitutional provisions called to our attention upon examining the law, though not specifically noticed in the objection taken in the records or briefs of counsel, that the Constitution may not be violated from the carelessness of oversight of counsel in any particular. 1895. Things have changed, all right? Then, of course, we come judicial supremacy. I mean, the essence of judicial supremacy today is the living Constitution, right? And all I can say about the living Constitution is it depends less on the Constitution and more on who is living. All right? It's a cult of personality, to bring it to the Stalinist level. It's a cult of personality. If you have one set of justices in there, you get one result. If you get another set of justices, you get a different result. And it really boils down to what I like to call the 5th fool doctrine. It's that last individual that can turn everything one way or the other. And then, of course, we come to the second great prong, if you will, of judicial supremacy, the so-called balancing test, which essentially says that the court can sustain, because we're not worried about them overturning something that's unconstitutional, but they can sustain an abridgment of a fundamental right if there is a compelling governmental interest in doing it. And if the government is doing this by the least restrictive means, if it's not as bad as it might have been, okay? They only send you to the concentration camp for 5 years instead of for life. All right, that type of situation. Now, what's interesting about that is that the analogy, you know, the balancing analogy is kind of a scientific one. We put something on this pan, and we put something on that pan, and we watch it go, okay? You actually read these cases, what you'll discover is, well, they're non-verifiable, they're non-falsifiable, they're non-repeatable, they're not even definable. There is no standard of balance. There is no unit. There is no actual set of scales that you can watch. You get a different opinion depending on which judge you look at, and you can especially see that now because they are becoming, or have been for the last, what, maybe 6 or 7 years, extremely acrimonious in the dissenting opinions that are going back and forth, right? There'll be a majority opinion and then a vicious dissenting opinion and footnotes in the majority opinion attacking the vicious dissenting opinion because they circulate these opinions before they publish them so they get an opportunity to shoot at each other from many directions, right? So they are terrifically divided, which tells you that the test, so-called test they're using, is not only a non-scientific one, it's a non-rational one, right? So we're dealing in the area of non-rationality. Thank you very much. X's reasons are better than Y's reasons, but there are no objective bases. I like chocolate ice cream, you like vanilla ice cream. That's it. Okay, that's it. If I get 4 people to go along with me, it's vanilla. Now, if you want to read a book that will curl your toes on this, it's by Mr. Lazarus, Edward Lazarus, called Closed Chambers, the first eyewitness account of the epic struggles inside the Supreme Court. 1998, wrote this book. This is a kiss and tell book. It's always been an article of ethics within the court that the clerks don't talk about what they did and who did what on the court, right? And there was a book by Woodward and somebody else who came out called The Brethren earlier, they had inside information from sources, but they didn't say who the sources were, so with Woodward you could never be sure, where this came from. This fellow Lazarus was a clerk. And he describes how they actually maneuver and manipulate and make deals. I'll vote for this case if you'll vote for that case. And the clerks, those are the justices, and the clerks maneuvering behind the scenes. And the interesting thing about it all is I believe it's true, and more than that, I believe that the justices are perfectly willing to operate under that set of principles. Totally political. Read that for yourself, and you'll see the impossibility of this system functioning. It makes Congress look like a paradigm of democratic government. Well, okay, all of this being true, what about the concept of judicial review? All right, the idea that the Supreme Court can declare a statute unconstitutional in case of controversy before it. Well, the answer to that's very simple. That's legitimate. Why? Because they've taken an oath to exercise the judicial power according to the Constitution. They're being asked to apply some statute to an individual in front of them, which they believe in good faith violates the Constitution. To follow that oath and not commit perjury, they have to say, in the course of exercising my power, which you're asking me to exercise now as to this individual, I refuse. I will not exercise the power against him because this provision is not constitutional. Now, notice, that applies just to this individual. All right? That same statute could be applied to somebody else out there, and maybe it will wend its way up to the court, and maybe it won't. Maybe a lower court will follow that precedent, maybe it won't. Maybe Congress will go along with it, maybe it won't. Maybe Congress and the President will think about it and say, the more I read that opinion, the more it seems to me to make sense. Let's repeal that provision. Right? This in the old days under the Founding Fathers was called the Adjustment Doctrine. This was the true theory, that when they had these clashes on constitutional principle, they would be adjusted politically by all three bodies trying to make a decision that would comport with the general interest, as opposed to the Supremacy Doctrine, which says that one will dictate to the others. And judicial review in that sense is fundamentally important simply because Congress and the President can engage in usurpation and tyranny. Right? There's no question about that. These are not people that are, well, what shall we say, necessarily saintly. Right? And so it gives a check from the judicial side, but as Hamilton correctly said, the least dangerous branch if it's done that way. Because the most power that they have in that set of circumstances is to set aside one conviction or one application in one case involving one set of parties, and then leave the rest of the matter to whom? To the three most important words in the Constitution, we the people, right? Because if we the people accept that result and do not accept what Congress and the President has done, what do? In the next election, we change the composition of those bodies, right? So it's not a complete check, but it's a check that starts in motion what is the complete check, which is control over the electoral process. Now, I could say a lot more, but I'm sure, as I sit here morally sure, that there must be some, probing questions. And I would be glad to entertain any of them.